Hey guys, quick primer before the sentencing hearing today on Murdaugh. For the murder counts, he's facing a minimum of 30 years each, up to life. The judge will decide that and decide how they run. Also, a thing to know is that in South Carolina, the Constitution of the state provides victim the right to be heard. And if you're a homicide victim will include a spouse, a parent, child, or a lawful representative. Also, we may hear mitigation things from Murdaugh's side. He may choose to speak himself, or potentially the judge will allow people to speak on his behalf. So I'm curious here about whether any family members from either side will step up for Paul and Maggie and actually say something to the judge in terms of increasing penalty, or about the crime itself, indicating their belief that he deserves to be punished. This judge has shown before that he doesn't really like to hear people second guessing the jury's decision, so I don't know how much patience he'll have for that. More if it's victims trying to say it, which would be unusual, but this is an unusual situation. Anyway, again, I think what will be interesting is who will speak on whose behalf here. I think it would be appropriate, obviously, to talk about the loss of Maggie and Paul, but I'm also more curious, really, from a legal perspective and just from the case, whether they will actually speak out against Murdaugh from either side of the family. Of course, the judge doesn't have to pretend to be unbiased here. He accepts the jury's verdict and their conclusion of guilt. I think it's one that he agrees with. That's done with. The guy's guilty at this point. This is only about sentencing. So people who like to scold the judges for acting like the person is convicted and is guilty, well, guess what? They are convicted and guilty, and the judge is totally within his realm there to agree with that and to say it, because that's the fact. This is just about the level of punishment. So a little bonus content is people are talking about, well, what will the appeal be? And the one thing that gets speculated a lot is the financial crimes aspect. And because there was so much of it at trial, there certainly seemed to be. Well, generally you can't allow in bad acts, prior bad acts, just to show the person's a bad person or whatever, but it can be allowed in if it can show motive, intent, other things. Really here it was for motive, so I won't go through the rest of it. To do it, you have to show that there was a permitted exception. Let's say that's motive. And the prior bad act has to be established by clear and convincing evidence. Well, they had that here because he admitted to stealing all the stuff. Then you have to have a logical relevance between the bad act and the crime for which the defendant is accused, and that's the motive. And if you disagree with that, you disagree with it. But that was, I think, the state's theory and part of why the judge allowed it. Even if it is relevant, the trial court should exclude it if the probative value is outweighed by the danger of unfair prejudice. That actually goes back to Rule 403. And that is supposed to be left to the sound discretion of the trial judge, although the Court of Appeals will sometimes second guess that. And there is a concept in South Carolina called the res gestae, which means that the acts being brought in are really part of this whole course of conduct that led to this crime. And so you can't have a picture of this crime without this stuff. And I think the judge debated some of that. I didn't hear all of it, but that could be another thing too. But if you're going to argue pro or for the financial crimes being in evidence, there's your legal framework for that. And we'll see what happens at the sentencing hearing. Thanks, bye.